Welcome, members. Is it better? Great. I call to order the meeting. Item 1, election of Deputy Chairman. Now, before the end of the close of the nomination period, one nomination was received. That is Professor Chen Wing-kwong. The nomination was made by me and seconded by Ms. Rebecca Chen. According to paragraph 8D of Annex 4 to the House Rules, if the committee decides that there is a need to elect a deputy chairman when there is only one nomination, then the nominated member would be designated the deputy chairman. I announce that Mr. Professor Chen Wing-kwong be elected as the deputy chairman of this Bills Committee. Congratulations. Item 2, meeting with the administration. We will now invite the government officials to come in. Welcome, government officials. Today we have Secretary for Health, Professor Lo Chong Mao, Permanent Secretary for Health, Mr. Thomas Chen Chung Ching, Deputy Secretary for Health, Ms. Joyce Kwok Sen Yi, Mr. Larry Chu, Principal Assistant Secretary for Health, Mr. Emmanuel Lam Hoi Yet, Assistant Secretary for Health, Dr. Edmund Fong, Deputy Director of Health, Ms. Fion Xie, Acting Head, Boards and Councils of the Department of Health, Ms. Rosita Tam, Chief Executive Officer, Boards and Councils of the Department of Health, and from the DOJ, Ms. Queenie Tong, Senior Government Counsel. Welcome all. Before the meeting, the Secretariat has received 2 submissions in relation to the bill. They have been sent to members and the government for reference. Members, please consider whether we need to invite submission from the public concerning the bill. There are many channels for the public to express their views, including written submission. I think the bill has a large impact on the public. It is of public concern, so I think we should invite public submission. Is there any objection? Ms. Rebecca Chen, please switch on the mic. Chairman, according to past practice, the medical registration bill ordinance has received a lot of discussion. So besides inviting written submission, since the scope of this bill is so wide, can we ask the government to confirm the number of patient organizations or patients themselves they have met with, and even medical organizations? If views have been collected from these bodies, they should be shared with us to avoid duplication of efforts. Now today, we have 2 hours meeting time. I believe many members will ask questions in relation to the bill. So I will invite the government, the administration, to give us some information in this regard later on. Now concerning the question on whether we will invite public submission, if there is no objection, we will invite the Secretariat to start the procedures. 2 has been received already. If we extend the invitation, I believe that more submissions will be submitted. So besides collating the views from public submissions, we will also invite a response from the government. So the notice will be on the website. Members of the public, including District Council members, will be invited to submit views on the bill. The next item. Now, the legal advisor has sent 2 letters to the government in relation to the bill. The government has already given a response to the first letter, which has been uploaded to the website as well. There is a second reply pending, which will also be uploaded. So we will first begin discussion of the bill's policy matter. Members who would like to speak, please press the button. I believe all of us has questions for the government. So now I will defer to the professor for introduction. Thank you. The Medical Registration Ordinance is the main principal ordinance for maintaining the professional standard of the medical profession in Hong Kong. Now, the MCHK, or Medical Council of Hong Kong, fulfills the statutory obligation in relation to the bill, in relation to the ordinance, including training of doctors, doctors' registration, licensing organization, the licensing examination, professional codes and guidelines, and also conducting disciplinary inquiries in relation to protecting patients' rights as well as maintaining the professional conduct of medical practitioners and supporting Hong Kong's development. The MCHK plays an important role. Now, in relation to the MCHK's recent works in the recent years, in particular concerning the mechanism for handling complaints, to implement the executive-led approach and improve governance, we have reviewed the ordinance to conduct a targeted reform to ensure that the ordinance can keep abreast with time to support the MCHK to fulfill its obligation so as to fulfill its mission. Now, enhancing the ordinance and reforming the MCHK is one of the important steps of modernizing our healthcare system. We seek to complete this step within this term of the government. There are 4 areas. First of all, reforming the composition of the MCHK and supports more diverse participation. The bill proposes to add 3 doctors from non-medical profession so as to enhance the ratio of lay members to 31%, so as to foster cross-disciplinary collaboration and take a wider perspective of views. We also propose to expand the scope of medical doctor members to ensure that they cover a wider background and professions, and also to ensure that the MCHK would take into account the government's healthcare policy. Now, Commissioner for Primary Healthcare or their representative will be added as ex-official member, and also the HKUST will also nominate 2 doctors as members. They will also be doctors directly appointed by the CE. Now, all members returned by election must be appointed by the chief executive so as to implement the executive-led approach. Second, we will reform the complaints handling system to make it more independent, fair, and transparent, and highly efficient. Concerning complaints, investigation, and inquiry, there are 5 enhancements. First of all, enhancing the positioning and independence. Now, the Preliminary Investigation Committee and the Inquiry Panel will be renamed as the Medical Investigation Committee and the Medical Tribunal Panel to distinguish their roles. The composition will be enhanced. The MIC and the MTP will be comprising 5 members, among which 3 will be independent assessors appointed by the government to ensure that the investigation and inquiry are directed by mostly independent assessors. We will also greatly increase the maximum number of independent assessors to 280 so that the inquiries and complaint investigation can speed up. Second, we will also enhance support for the MCHK. We will enhance the power and professional support for the inquiry or medical tribunal panel. The MTP will be empowered to summon persons to give evidence or produce documents in their possession They will also be able to delegate its powers to dedicated investigators. The legal advisor will also be allowed to provide legal advice at the initial stage of investigation to speed up the process and enhance its quality. Now, with these enhancements, we also propose to revoke the mechanism to allow back referral by the MTP to the MIC to save time. Now, the Department of Health can increase support for the MCHK through manpower support as well as system upgrade. 3, setting milestones and time frame. Now, the MCHK will be empowered to issue directions to require parties to follow a timetable. They will also be allowed to set milestones for different steps of the process to make the process more transparent. 4, better system of sanctions. Now, the bill will set a 4-tier sanction system as well as cancelling the power to suspend the orders. This will make the sanctions more proportionate. Now, the 4-tier sanction includes permanent removal from the register, a time-limited removal of the name from the general register, suspension of practicing certificates and automatically resume the certificates, or order the validity of the registration to be subject to any conditions, including receiving retraining in the medical profession to provide better safeguard. 5, enhancing the system of review and appeal. Both the complainant and the medical practitioner concerned can apply to the MTP concerned for review of his decision. For a minority of judgment, if the Secretary thinks that there are insufficiencies, the Secretariat can lodge an appeal to the Court of Appeal to ensure fairness. Now, since the MCHK will play a larger role in the future, the chairman of the MCHK, as the leader of the MCHK to discharge his duty, his position is extremely important. Now, to avoid confusion of roles, chairman of MTPs should not be the chairman of the MCHK, so as to highlight the independence of the MTP. It will also allow the MCHK to review the judgment rendered by the MTP from a fair point of view. Now, we will also enhance the mechanism to handle doctors convicted of criminal offences. The medical profession has been held in high regard, and doctors are trusted by the public. Now, the bill proposed that for doctors convicted of offences endangering national security and other serious criminal offences, for example, murder or rape, their registration would be revoked immediately. Depending on the sentence, they will lose their eligibility to register permanently or for a certain period of time so as to safeguard the public and national security. Now, for imprisonment sentences in relation to charges in relation to medical practice, or if the doctor is found not suitable for trial because of other reasons, the arrangement will also prioritize safeguarding the public. Now, fourthly, we will also enhance the professional competency of doctor and also manpower supply. We will extend the mandatory continuous medical education to non-specialist doctors. This will also be a prerequisite for applying for renewal of their practicing license. This will ensure that all doctors continue to develop their skills.
途徑上 In terms of manpower, given the shortage of doctors, we recommend that building on the specialist registration path, we propose allowing permanent residents and non-permanent residents to be able to register as specialists. The government and the hospital authority will give priority to hiring locally trained doctors. Our proposal will not affect the career prospects or specialist training or internship prospects of local graduates. We value the input of stakeholders. During the drafting of the bill, we have been in touch with the key stakeholders. Ms. Rebecca Chen just brought up this point. We talked to key stakeholders, the medical council, and different organizations, including 9 patients organizations, 4 training institutions, 11 doctors groups, etc. We briefed them on the government's proposal and the directions. We also heard their views. After the bill was gazetted, we continued to take these stakeholders through the content of our bill. We also attended events for the stakeholders and briefed the public on the bill. Here on the bill, for the groups and individuals who shared their insights with us, I want to express my gratitude to them. The work of the Bills Committee starts today. I want to express thanks to Professor Grace Tang, chairwoman of the Medical Council. She took over in 2024. Since then, she has fulfilled her duties. Since January 2025, she implemented administrative measures to raise the overall efficiency in dealing with complaints within the existing legal framework. She also directed that the Secretariat direct more resources to case handling in terms of stock taking and handling. And she also set deadlines in terms of the replies from experts. Under the leadership of Professor Grace Tang, the backlog has massively shrunk. From the Medical Council, we learned that when the Ombudsman made this report earlier this year, in terms of the 18 outstanding cases from 2018, most of them have been completed by now. Only 5 are left. For all 5 cases, the inquiries will start within this year. At the end of last year, Professor Tang also led the Medical Council in reviewing the complaint mechanism of the MCHK. A report has been submitted to the Health Bureau. And that laid a solid foundation for our proposal to improve our institutions. Health is the greatest asset. People entrust their health and life to doctors. This kind of trust in doctors is unique. Trust between patients and doctors is the cornerstone of our healthcare system. Our status that we enjoy today is hard-earned. It's built with the trust between doctors and patients. What we propose now is a root and branch reform rather than a band-aid, so that there is diversified participation and we bring our system up to date. As we maintain professional autonomy and procedural justice, we enhance efficiency and transparency. We maintain public trust in the system. The Health Bureau proposed this change last year. Since then, we have been in touch with members of LegCo before and after the bill was gazetted. We had in-depth discussions with members. We will fully cooperate with the Bills Committee's deliberations. I hope members can support the bill so that we can secure its early passage. Thank you. This bill is vital in terms of maintaining or upholding the conduct of doctors and also the well-being of patients. The Secretary just mentioned more than 20 engagement sessions with in-depth discussions with groups. What are some insights that we have gleaned from those exchanges that the Secretary can share with us? If you cannot discuss that off the top of your head, you can provide us with the paper after the meeting. we can provide a summary of our exchanges, and then we can submit that to the Bills Committee. We will invite public submissions. Still, the input from the 20-plus groups provided previously will be valuable for our deliberations. 10 members have pressed the request to speak button. For the first round, let's do 4 minutes per member, question and answer inclusive, and we will see if we have time for a second round. Here's the sequence in which members will speak. Reverend Peter Kun, Ms. Christine Fong, Mr. Adrian Ho, Professor Chen Wing-Kwong, Dr. Thomas So, Mr. Jonathan Leung, Mr. Ken Lee, Ms. Rebecca Chen, Ms. Elaine Chick, Mr. Holden Chow, Dr. David Lam. Ms. Christine Fong. I would like to see the early passage of this bill. It often happens. Disputes between doctors and patients, complaints are lodged. This proposal represents a comprehensive reform. There will be more members sitting on the medical council. I support that. I also have another concern. The complaint system will be broader, involving more people. So in terms of investigating cases on the part of the MCHK, can we have timelines? Will there be forms for the public? When people file a complaint, they use the form and then they submit the statutory declaration along with the form. And then after the complaint is filed, how long will it take before an inquiry is held? How long will it take before the complainant gets a reply? If a medical report is needed, say the case involves a public or private hospital, will the MCHK have the statutory powers to require the hospitals involved to provide the medical report sooner? The Security Bureau will also be updating our laws on sexual offenses. After our current proposal is enacted here, will we update our laws in tandem with the changes to the Crimes Ordinance Cap 200? On manpower, the MCHK lacked proper personnel on cases. Since we propose putting more officers at the MCHK, how many extra officers will there be and how much in terms of extra resources is needed? Secretary, I will take the first 2 questions. On the point about manpower, the Department of Health will go into greater detail. First, on timelines. For the complaints, investigation, and inquiries, there are many milestones. Ms. Fong's question is whether a date for the inquiry can be set early on. That's not our goal. This is a quasi-judicial process. The process goes from screening to investigation and then to the inquiry. Many details are involved. There are complexities that will affect the date of the inquiry. We will not require the MCHK to provide a hard and fast inquiry date. The case has to be completed within 2, 3, or 5 years. There are indeed complex cases, potentially involving crimes or a coroner's inquest. We will have to wait for the results from those sides to come out before the MCHK's inquiry can proceed. In terms of the timelines we have in mind, we're talking about the administrative details. The complainant has to submit a statutory declaration. They have to submit the supporting information. Ms. Fong mentioned securing their medical reports, and also experts have to provide their own reports. If the submission happens after the deadline, we will follow up. We also need transparency to make sure the complainant has access to the information. On the sexual offenses, we understand there will be a change. Before the change is enacted, we stick to the current law. Once the change to the sexual offenses are updated, we will update our list accordingly. On manpower, it's not just about the medical council. Other boards and councils are also moving with the times, and that means more workload for them. The Department of Health will take a holistic view of their manpower. Submissions have been received on this. Dr. Edmund Fong from the Department of Health can tell us more about that. In the future, the Department of Health will introduce a range of improvements to support the MCHK. We will appoint senior management staff with professional experience to serve as the secretary of the MCHK. There will also be greater administrative support in terms of holding meetings. The DH will also explore the idea of setting up dedicated teams for investigating complaints. These dedicated teams will be staffed by professional officers, and there will also be greater support in terms of legal support to ensure greater success on the part of the MCHK. Referent Peter Kuhn. Thank you. I have a question about reviewing and appeals. And the inquiry panel can review a case on its own initiative 14 days after a decision that's within the existing framework. There was this incident involving the MCHK reviewing its decision on its own initiative. There is something bizarre about the logic. So the inquiry panel completed an inquiry. They made a decision. What triggers a voluntary review? Is it public pressure? As a matter of justice, can we spell out how this works? And then also about the date. The doctor aggrieved has a month. Are we talking about a month after the 14-day window? A decision may be in favor of the doctor, so there will be no appeal. But then if the decision changes after a review, when does the clock start for the month that the doctor gets? The doctor will need time to prepare for any potential appeal too. We have to be fair to both sides of an inquiry. It's all very well to have the review on the MCHK's own initiative. There may be public outrage, and then the MCHK reviews the case. But if there's no outrage, no review follows, I think something is wrong about this. I also have another question. Inquiries may take a long time. Before an outcome is available, do we have to make public the name of the doctor? Otherwise, you get a trial by public opinion.
Secretary. Now, first of all, review and appeal are two different concepts. Now, the inquiry panel or the medical tribunal panel, which will, that's the new name for the IP. The inquiry panel will first look at their judgment and review whether they are problematic. So this mechanism also exists in the judiciary. If the inquiry panels find any problems, they can correct themselves. Now, under the bill, both parties will be allowed to apply for a review to be conducted by the inquiry panel. It is not a new trial, but rather a review on whether there are blatant issues procedurally. So both parties may apply for a review. Now, on the other hand, an appeal should be lodged with the Court of Appeal. Under the existing mechanism, the doctor under complaint can file for an appeal. But there is not a mechanism for the complainants to lodge an appeal. Now, the IP or the MPP in the future has a similar role as a judge. So under the bill, a new mechanism would be added. The Secretariat, in other words, the prosecution, if they find that there are judgments in contrary to the public interest, then they may lodge an appeal. Now, for most of the cases, the judgments rendered are fair and just. However, for problematic cases, the Secretariat may lodge an appeal with the Court of Appeal. Now, what about the identity of the doctors? The inquiries are held in public. So in the inquiry stage, the information about the complaint doctor would be published. Members of the public will have access to the details of the trials. So that would be the same for inquiries conducted by the MPP in the future. They will be held in public. Next, Mr. Adrian Ho. Thank you, Chair. I fully support the amendments. There are several areas which I seek clarification from the Secretary. That's about the serious criminal offences listed out in Annex C. So in setting out this annex, what are the standards adopted by the government? Now, some sexual offences, for example, indecent assault, they are not included in Annex C. In recent years, there have been some cases about doctors involving in indecent assault. So although indecent assault is not the most serious sexual offences in Annex C, that will also cast doubt on the doctor whether he's still suitable for practice. So what is the government's view on indecent assault? Second, now if a doctor is engaged by the government or invited by the government to give advice to committees, then no disciplinary proceedings may be initiated on these advice. So did you include this in the bill? Because there has been past incidences of doctors being investigated for their advice for the government. Third, the Secretary may, in the name of public interest, issue directions to the MCHK. So what does it mean by public interest? How do you define that? 3 questions, please, Secretary. First of all, concerning serious criminal offences. Now, first of all, the standard for doctors are high because they come into contact with patients on a daily basis. Now, for indecent assault, if in the line of provision of medical services, the doctor commits the offense, resulting in imprisonment, then the doctor's practicing certificates would be automatically suspended pending the inquiry by the MCHK. concerning advice given to committees and the exemption. Indeed, it happened in the past. Some doctors gave medical advice in the context of government's committee. However, complaints were filed because they disagree with the expert opinions given by those doctors. And that has become a basis for complaining that the doctor's standard falls short of expectation. So that has no correlation with a doctor-patient relationship. That is, the complaints do not happen during the course of provision of treatment. In order to ensure that doctors can give their expert opinions with no worries of being complaints, the bill proposes that advice given to committees should not be grounds for complaint to the MCHK, because those opinions are based on professional judgment. Different doctors would have different professional judgment, and this should not become a cause for complaint. Now, finally, for some minority situations, for example, major public health incidents, when we require detailed information from the MCHK and for the MCHK to align with our policy, then we may issue directions to the MCHK. So these are very serious public health crisis that we are facing, for example, an epidemic. The need may arise, so that's how it comes into place. Professor Chen Wing-Kwong, Deputy Chairman. Thank you, Chair. I'm pleased that the government takes the initiative to amend the medical registration ordinance to enhance the complaint handling mechanism of the MCHK to respond to public's concern on its complaints handling. Now, I have the following questions. It is a widely known fact that the MCHK has been criticized for its long handling time of complaints. Now, according to the Ombudsman reports, between 2020 to 2025, the average time of handling by the PIC is 10.4 months. That's for the PIC stage. For inquiry, it's 11 months. For some individual cases, it took more than 102 months, that is 8.5 years, for the PIC to conduct the investigation. So after the enhancements of the bill, how much more workload do you expect the MCHK to handle, and how much time can be saved? What are the ideal waiting time for each case? Is the government confident that there will not be another delay of 10 years? Secretary. Thank you, Professor Chen. As we mentioned, there are several stages. The first stage is screening by the PIC. The chairperson of the PIC would look at the initial evidence and decide whether the cases are groundless or frivolous. Some complaints have nothing to do with professional misconduct. So the chairman of the PIC would make a decision together with the deputy chairman, who is a lay member. On whether to refer the case. Now, according to our statistics, the average time is 12 months. Now, for some exceptional cases which are very complicated, for example, delay on the part of the complainant in providing a declaration under oath, and also the delay in obtaining information from the doctor under complaint, these added together may result in an unacceptably long waiting time. But that is an accumulation of factors. So with the bill, we will allow the MCHK to set milestone dates and targets. Now, for the screening stage, we can slash the time by half, that is from 12 months to 6 months. Then a decision will be made by the PIC. Now, for the investigation stage, that would be more complicated. If there are evidence to refer to the inquiry panel, now the average waiting time is 3.5 years in the past. Now, with the reform, we expect the waiting time to be shortened to 3.5 years. So that is the investigation stage we are talking about. Those are more complicated cases. We have already screened out the groundless or frivolous cases. Now, for serious cases with sufficient evidence, and for these cases, the waiting time will be shortened from 3.5 years to 2.5 years, but that's the average only. There are some exceptionally complicated cases, and we can't make a promise that we can finish all the cases within a certain period of time. Sometimes it also involves criminal investigation. But generally speaking, we can shorten the waiting time from 3.5 to 2.5 years. Now, about the targeted number of cases completed, it depends on the caseload. Now, as the complaints handling body, the MCHK is under huge pressure. For example, during the epidemic or earlier on during the Black Lives violence, there was a sudden surge of complaints numbers. Now, the average number is about 600 cases per year, but there was a time when there were 2,000 cases per year. It was due to a lot of different factors, even political factors. Now, the average is 600, so our target is to complete all the cases in the year. Thank you. So the shorter the wait, the better it is for the public. That's for sure. Let me put it this way. It's not just good for the public. It's better for the doctors under complaint as well, because they want to finish the procedures as soon as possible. An answer should be given as soon as possible as to whether a mistake has been committed on their part. If not, they should be allowed to continue their services. Once under complaint, at the PIC stage or in the future, the MTP stage in the future, the doctors will be enabled to obtain a certificate of good standing. That is to prove that the doctors are not under complaint. That is a great blow to any professional medical practitioners. All doctors would like to finish the procedures as quickly as possible.
Dr. Thomas So. I support this bill. I have a question about the same matter. How do we shorten the whole process from the perspective of the system? As the Secretary said, it's not just about the public or the patients. Doctors also want to see faster resolution. The paper has this to say: a complaint is filed against a doctor's professional misconduct. I have read the ordinance itself. There is no definition of professional misconduct in the ordinance, so I referred to the professional or practice guide of the MCHA. Based on the Code of Professional Conduct, the scope of professional misconduct is very broad. Of course, most of it has to do with the patient's interest, and then part of the definition also has to do with referral or financial arrangements or dealings between the doctor and other professional organizations. So all those actions count as the professional conduct of a doctor. Last year, there were 800 complaints, and then 252 cases required more than 6 months to handle. Can we first look at the severity of the cases? Now, some kinds of misconduct may have nothing to do with the patient's interest. Can we have some sort of summary approach to the open and shut cases? And the paper says the MCHK will be able to issue guidelines and set different timelines. So my question is, for the less serious complaint, can we have a fast track approach for such cases, and that will make better use of the finite resources? There's no clear definition of professional conduct. Part 3 has this to say. For doctors found guilty of criminal offenses related to their professional practice, the certificate of practice will be suspended right away, given the unclear definition. Can we have a clear definition on criminal offenses related to a doctor's professional practice? Otherwise, this nebulous concept bothers doctors. What do you mean by criminal offenses related to medical practice? Say I run a clinic. Something is wrong about the financial statements. Does that have to do with medical practice? The Code of Professional Conduct also covers financial arrangements or dealings with other organizations in terms of finances. Those aspects may constitute professional misconduct. Secretary. On doctors' professional conduct, the point is clear. It is broad in scope. It's not just about providing medical services. In the day-to-day operation of a practice, finances are also a key area. Say, a doctor cannot take kickbacks. This is potentially criminal if a doctor is engaged in such practice. So the doctor cannot just refer a patient to a service and then split the revenue. Doctors cannot advertise their services. This is taken seriously in the medical community. For complaints, they don't always come from patients. Complaints can also come from doctors. Dr. A may see Dr. B advertising their own service. Indeed, professional conduct covers a wide range of areas. The MCHK handles all such complaints. On the suggestion about classifying complaints and expediting the approach, we first have to look at the substance of each complaint. That's why we will have the Medical Investigation Committee's chairperson and deputy chairperson look into the groundless and frivolous complaint, and then the complaint stops there. Some people also file a complaint but fails to provide follow-up information, or people come with the wrong information, or the complaint has nothing to do with the medical practice. Say, a complaint may be about a doctor making noise in their home. This has nothing to do with professional conduct. So a screening process is needed to make sure we don't waste time. So on crimes related to medical practice, this is clear. Let's say a doctor is accused of stealing things. If the stealing happens at the clinic, or it's some sort of family dispute, those are two separate cases. Or careless driving. Careless driving has nothing to do with medical practice. So we have to treat these cases separately. If it is a mistake made in the course of medical practice and there's an imprisonment sentence, that would be a more serious matter. On finances of a doctor's clinic, this is part of a doctor's medical practice. So this is about taking rebates. It's a professional matter. It's about conduct that the MCHK looks into. Thank you. Mr. Jonathan Leung. The Liberal Party and I support the Medical Registration Amendment Bill 2026. As the Secretary mentioned during the second reading, it's about reforming the complaint system. It's about safeguarding the public, maintaining professional standards, and ensuring the supply of doctors. On the third item, when a doctor is found guilty of offenses endangering national security or serious criminal offenses, this will be linked to the license of that doctor, and it's only right for us to do it. And also, item 4, removing the status of being a permanent resident as a bar in taking specialist exams. This is something the Liberal Party has been calling for over years. Now, the complaint mechanism is close to the heart of many. We did not propose a separate mechanism from the MCHK, but here the proposal represents a root and branch reform. We support this, so the government will get involved. The 32 members will all be appointed by the chief executive. We support that. Now, my question. The PIC and the IP will be renamed. The PIC will become the Medical Investigation Committee. The IP will become the Medical Tribunal Panel. So what will be the change to the substance? Other than the change in the label, will there be more members? Now, on the independent assessors, what sort of qualifications and experience do we mean when we refer to the independent assessors? Some cases took many years to process at the MCHK, taking more than 5 years. After this reform, the terms of the current MCHK members may expire. Will that lead to handover issues? Will that slow down the process? We will see 5 people on the MIC instead of 7. More cases will be covered. But then with fewer people on the MIC, how will the support work? How will we provide resources to make sure the efficiency remains unchanged or even go up? On the PIC and the IP, renaming them is important. The current naming scheme is confusing. So the PIC investigates the matter and then the case goes to the inquiry panel. People get the false impression that the inquiry panel is somehow subordinate to the PIC. That's why we propose renaming these two bodies. First, you have the PIC. It's a committee, it investigates a case and then it submits the information. And then the inquiry panel will be renamed as the Medical Tribunal Panel. So the MTP will not be just part of the MCHK. 3 members of the panel will be chosen from the assessors independent of the MCHK. There will be 280 independent assessors with both doctors and laypersons. So the tribunal will not be just about the MCHK. There will be a greater element of independence and hence impartiality and credibility. On the qualifications and experience of the assessors, currently we rely on the administrative staff of the Department of Health. They are not professionals in medicine. In the future, we will assign more senior, more experienced, with a professional background in medicine to the Secretariat. They will assist the Secretariat. The investigation will also be undertaken by the professionals on the handover. The inquiries will not be held by the MCHK members. It will be the independent assessors nominated by different bodies. If an inquiry has started, the members will serve out the inquiry before handing over the term. Next, Mr. Ken Lee. I welcome the Medical Registration Amendment Bill 2026. Great work. In the past, only the doctor facing the complaint can appeal the decision of the inquiry panel. Now, even the complainant will be able to lodge an appeal, and we'll also see in this attempt to streamline the procedure, there will be 5 instead of 7 people on the MIC, so more investigations can proceed in tandem. And there will be no more referring back of cases. That's to be welcomed. I also hope there will be computerized management of cases so that there will be automatic alerts and follow-up. I have a couple of questions. The first was touched upon by Dr. Thomas So. The Ombudsman mentioned that some medical disputes simply have to do with the services, and they should be treated separately from the medical practice of doctors. Will there be a future mechanism for triaging the complaints to make the best use of resources? Now, on time management, in December 2025, there were 900 outstanding complaints. 16% took more than 2 years. I don't know if those cases involved the referral back of the cases, leading to cases taking up to 8 years. Will there be a deadline for clearing the backlog? We will stick to the 2.5-year timeline. Each year we'll get 600 new cases. How long? Maybe 3 to 5 years to clear all the backlog cases. How long would that take? Secretary. As the member said, some complaints are really just dispute about the services. Indeed, some complaints have nothing to do with a doctor's professional conduct. It's just dispute. The chairperson of the MIC will have to make a decision after reading the preliminary information. We value every single complaint. So the chairperson screens the cases, and then with the consent of the deputy chairperson, a case will be dismissed if the facts have nothing to do with the doctor's professional conduct. Again, this will be up to the chairperson and deputy chairperson of the MIC. On cases that drag on, we have looked into the example cited by the Ombudsman. One such case involved referring back to the PIC by the inquiry panel. New evidence emerged. For example, the coroner's court handed down a new ruling. There was a case that was referred back twice. First, because of the coroner's decision, and then the second time it was a change in the expert witness because it took too long. The expert witness refused to serve as the witness. With the change we propose this time, there will be no more referring back of cases, and we will see no more of such situations where a case is still in the loop 10 years later. But there are cases where things are just inevitable given the judicial system. It's a cross-judicial process. For example, when the coroner's court hands down a ruling, we have to wait for the outcome before the inquiry panel can proceed. The same goes for criminal offenses. The criminal trial may take years to complete. We have to adhere to procedural justice, meaning we have to wait for the court judgment. If evidence is accepted by the coroner or a criminal court, then the MCHK will not have to go through the evidence again, then that will save massive amounts of time. On the last point, the overall time. We want to be able to commit to a time too, but then cases vary wildly. Some cases involve the coroner's court or criminal investigations. We have to make sure we do not undermine the criminal investigation or procedural justice. We have to wait for those cases to conclude. Rushing to a hard and fast deadline would be impossible, and this is something we want to stress too.
Next, Ms. Rebecca Chen. Thank you, Chair. Now, for many years, the MCHK's handling of complaints has been the subject of criticism. Now, there are areas which can be improved without the passage of this bill. First of all, the secretariat of the MCHK and how it follows up with the case. Now, it's like a pen friend with the media. Now, I have a case. I'm the complainant of a case. When I call the secretariat, they would ask me to write them a letter. There is no follow-up at all. It's very difficult for me to know which stage my case is in. Now, like another case, it took 15 years to complete. Even without the reform, the secretariat can improve on its administration. So can we ask the MCHK Secretariat to improve its handling of cases and also the communication with the complainant? At least tell the complainant what stage the cases are in. These can be done by the Secretariat even before the reform. Second, how much can the bill help with the handling of complaints? Now, the complainants have to fill in a form about the background of the case, for example, the name of the doctor and also the subject matter. The second stage is for the patients and their family members to provide evidences, including documentary proof, audio and video recording, and so on. This is where the delay lies in. It takes a long time for the patients and their family to gather evidence. That would still be true after the passage of the bill. So how can we make it easier for the patients and their family members to gather evidence? In my case, I still haven't got the medical report from the hospital authority after a few months' request. So when we are asking patients to submit their medical proof, that doesn't have to do with the composition of the MCHK and the bill. Now, moving on to the reform's content, I seek to clarify one point. Now, how can the MCHK enhance its investigative power? That's very important. Now, there are some enhancement measures, including that the secretariats can appoint investigators or assessors to conduct the investigation. So what are the required training for these assessors or investigators? Now, in the UK, this is a paid occupation where the medical authority has to provide training to. Not just anybody can become an assessor or an investigator. So is there a standard for training for these medical investigators? On the other hand, Will the Department of Health assign the investigators upon the receipt of complaints, or will there be a team of investigators who conduct investigation on their own? Now, if the training is provided by the government, what is the content and how many hours of training will these investigators receive? 3 questions, Secretary. Now, in my opening, I have already mentioned, I repeat here, that the incumbent chairperson, Ms. Grace Chan, upon taking office in 2024, she has initiated a lot of administrative improvement measures, including under the existing legislative framework, exercising supervision on the performance of the secretariat and also setting milestones and targets for the secretariat. So that's what Professor Grace Tang has done. So after the publication of the Ombudsman report in half a year's time, hundreds of cases have been cleared, which have been widely reported. So that's what the MCHK has done even before the reform. We emphasize that the Department of Health also provides a lot of support to the Secretariat. However, the manpower and additional resources are not in place yet. Still, the Secretariat has worked hard to clear the backlog of cases. So we thank the incumbent chairperson and the members of the MCHK for their hard work. Concerning submission of evidence, it is true that we rely on the complainants to provide sufficient evidence for the MCHK to work on. Now, according to the Personal Data Privacy Ordinance, the hospital authority has the duty to provide a copy of the medical record to the patient within a month's time. Concerning the investigative power of the MCHK, the expertise required of the investigators and also how it is done, that is within the realm of the MCHK on how they perform their duty. The MCHK is a statutory body. This exercise is to empower the MCHK to fulfill their duty. It is not the Health Bureau's ambit to direct how the MCHK performs its duty. For example, it is up to the MCHK to set milestone days and time frame targets. Having considered their operation, reasonable targets would be set for the complainants to fill in the forms and also for the hospitals to provide the medical records. So the MCHK will be empowered to issue directions. Chair, my question has not been answered. Now, the Secretariat will be allowed to appoint investigators. All along the hiccups lies in the investigative stage. Will there be training standard for them? That's not something we will stipulate by law. Now, the bill provides that the MCHK may appoint investigators. At present, the administrative staff of the DH would conduct investigation themselves. After the reform, the MCHK Secretariat will be empowered to appoint professional investigators to conduct investigation on its behalf. But that is not stipulated in the guidelines. Is that true? The MCHK would decide what kind of investigators they need. They may appoint someone with a medical background, a nurse, or other professionals with the relevant experience or who have been engaged in investigations. That's up to the MCHK. We will not stipulate all these details and put a straitjacket on the MCHK. The amendment is for empowering the MCHK to do so. If there are further questions, I may entertain the second round. Next, Ms. Lin Shik. Thank you, Chair. I think the public has high hope for this amendment exercise. We hope that the perception of the public that the MCHK delays and drags on in its complaints and is unfair will be vindicated. So after the reform, the waiting time will be shortened, and the Secretary has said that the government will not set a hard target. But will there be indicative time frames? For example, by a certain year, all the cases pending must be reviewed. The progress must be looked at. Will there be such a mechanism? Second, in relation to Ms. Rebecca Chan's question concerning the Secretariat's power to engage investigators to gather evidence, I have the same question. We are empowering the Secretariat to make the appointments, but will there be guidelines on the competencies of the investigators, for example, legal or medical background? And during the investigation process, how will the personal privacy of the patients be protected, and also the patient's confidentiality? Will there be guidelines for the Secretariat to refer to? Now, the bill also imposes a mandatory continuing education requirement to all non-specialist doctors. I agree that we need to enhance the overall standard of the medical profession, but there is already a shortage of medical manpower. If thousands of doctors working in the community are required to attend professional training during their busy daily work, that may not be good. So the government provide a transitional period for the doctors to comply with this requirement. Will there be supporting measures to ensure that there will be a wave of retirement of elderly doctors because of the high cost of compliance? Secretary, in terms of the timeframe targets, as I said, I'm not setting a hard target for individual cases. If criminal investigation or judicial process are still pending, then it is impossible to complete the cases. However, the Medical Council has already set targets for submission of replies and expert reports. There are clear timeframe targets. The Secretariat would pursue the matter if the deadline is exceeded. So that is already done even before the legislative reform. And that's also why so many cases in the backlog have been cleared.
On how the Secretariat will find the investigators and the qualifications needed, it's up to the MCHK. We empower the MCHK to do the work. We do not specify the details of investigators. So we do not mandate a doctor's qualifications for each investigator. It really depends on continuous medical education. We want to stress that medical education moves fast. We don't see why general practitioners do not have to keep up with the latest development. Take vaccination as an example. Family doctors have to get involved. Or the influenza. We have an in-depth discussion about that every year. Any doctor should be required to undergo continuous training. So it's about quality, it's about public safety. We have reached a stage where we should not exempt doctors from continuous medical education. It's not good enough for a doctor to stick to what they have learned 20 or 30 years ago. It's about keeping the public safe, and it's also about ensuring the quality of medical services. We will help doctors with that. Some doctors may struggle to adapt to the need to receive continuous education. Meeting the requirements of CME will not be hard. There will be short courses or even online seminars. That sort of training will be good enough. That will count towards the CME requirements. So there will be support for GPs. Thank you. The secretary was making a point on the question from Ms. Ling Chick and another member on the qualifications of investigators. I think the question is not about the hard and fast qualifications. What the members were after was a framework. The secretary said a different investigator will be needed depending on the case. So do we have a framework in terms of, do we have any normative guidelines on what we look for in investigators? I cited many examples. In the complaints we received, not every complaint involves life or death of patients. Maybe it's Dr. A complaining about Dr. B trying to advertise their service, or it's about finances. So we will not be too rigid in what we require from an investigator. It's up to the medical investigation committee. After looking at the case fact, maybe it's a case about improper advertisement. So in that case, an investigator with a different background may be needed. So we don't have to be too restrictive in the language in the law on what we look for in an investigator. In some cases, even the administrative staff from the Department of Health are good enough, but in other cases, professional staff may be needed. In some cases, we may need a doctor to assist with the investigation. That's why I said we don't want to box ourselves in. Instead, we empower the MCHK to make that decision along with the Secretariat on who they appoint as an investigator. Mr. Holden Chow. I have a couple of questions. I just heard the detailed response from the Secretary, so I want to write on the response. In the past, some investigations dragged on. So there were times when a case reached a certain stage and then those cases were referred back. Now we propose to abolish the referral back system. That's welcome. On manpower, other members asked about investigators. Now for investigations involving medical negligence, as the Secretary said, we find the investigators based on the circumstances. Those investigators will need a certain level of professional expertise. Even for solicitors working on medical negligence, those more familiar with the matter know what to look out for. I understand why we don't have to spell everything out in the law. Will there be suitable training for the investigators? This is an area worth considering. Investigators have to ask the right questions. Doing so will have a bearing on the outcome of the investigation. For the reform, Part of it has to do with expert witnesses. Cases that dragged on in the past sometimes involved difficulties in finding expert witnesses. That happened to some cases. I can understand why that happened. There are only that many people you can approach as potential expert witnesses. If I were the expert witness, I would have concerns. I would be reluctant. It's a small profession, so that may be one concern. When we approach an expert witness, of course, there will be remuneration. I understand that's only a modest sum. But the expert witness may have to invest a considerable amount of time and energy into the work for a modest return. And that may be why doctors are reluctant to be expert witnesses, and then the case takes so long. So for the current reform exercise, so I'm not just calling for remuneration. I know the sum is modest. Is there something else we can provide for expert witnesses so that they think it's worth their while acting as expert witnesses given the cost? Securing expert witnesses is crucial to cases. So that's my question. On appointing outsiders or professionals for investigators, that is beyond the scope of the Health Bureau or my purview. Now the work is done by the PIC. In the future, the PIC will be renamed as the Medical Investigation Committee, or MIC. The law seeks to empower the MIC to appoint investigators. The 5 members of the future MIC may not be up to the task by themselves. That's why the bill seeks to empower the MIC to appoint outsiders as investigators. We first need the law that empowers the MIC to do this. Otherwise, you just get the 5-member MIC and the Secretariat. They may struggle when the matter is highly professional. But we cannot make the decision on the MIC's behalf on what investigators needed for each and every case. That's why we stress that we're simply trying to empower the MIC so that they can make the optimal decision. On expert witnesses, there were cases where we had to wait for the expert witnesses' report, and then there were problems with the wishes of the expert witness to serve, and then there was cases when the expert witness refused to serve as the expert witness when the inquiry came, and those were factors holding back the inquiries. Mr. Chow highlighted a valid concern. I served as an expert witness too. It involved a patient staying in the ICU for months. I got boxes of reports. I had to write the report after going through all the papers because the doctor and the patient's well-being were on the line. It was tough. Money will not be a major incentive. Now, the Hong Kong Academy of Medicine is the largest pool of experts. They encourage their academicians to actively support the MCHK's work. Again, we also have the hospital authority with doctors from many specialties. The doctors from those specialties actively support the MCHK's work. When reports are needed or expert evidence is needed, the hospital authority tries to help. The medical profession supports the MCHK. If the MCHK struggles, the quality of medical care will suffer. Public trust in the medical profession will also suffer. Dr. David Lam. Regulation of doctors has always been a bread and butter issue. This amendment bill is close to the heart of doctors. We serve the public, we save lives, we serve the sick and injured with compassion. That's our watchword. Rigorous regulation and full compliance should be visible, and that will set a good example, and that will raise public trust in doctors. I support this bill. In the days to come, I will also do my job in the clause-by-clause scrutiny. I have some follow-up questions based on the previous exchange. Now, on Section 32A, Bracket 2, now it's about doctors providing advice to statutory bodies or organizations as a third party. The MIC will not hold doctors liable for the advice provided in such a capacity as long as the advice is given in good faith. Does this exemption also cover the advice given to the MIC or the medical tribunal, and also on review and appeals? When the MTP holds an inquiry, the inquiry concludes. That's when the clock starts for the appeal window. Does that also cover a review? Does the clock for the appeal start only after the review ends? My next point has to do with investigators. Can we have a regular establishment of investigators for the MCHK? Otherwise, where will the money come from? Secretary, on the exemption of liability, that will cover expert witnesses. For complaints and also in policy making, we need advice from experts. The experts tell us what they think is the best approach. People may disagree with the advice. There was a case when an expert gave their advice on a certain case, and then the complainant felt it was the wrong advice, and then the complainant found another witness who argued that they disagreed with the first expert's advice. And then there was an accusation that the first expert witness fell below professional standards. For expert witnesses providing advice as a third party, this expert was not involved in the patient's care, simply commenting as a third party. Other parties are free to accept or reject such advice. It happens all the time. Two experts can disagree on a matter. An expert should not be accused of professional misconduct or falling below professional standards after giving advice. If an expert witness can be sued, then we end up muzzling experts. No doctor will be comfortable with serving as expert witnesses. So for investigations and inquiries, when experts are invited, we have to make sure experts won't have to worry about being accused of professional misconduct as a result of providing their advice.
Concerning the review of judgments, yes, about review and appeal. Now, according to the judiciary's rules, it's usually within a month when an appeal could be lodged. Now, I would defer to the Permanent Secretary, Mr. Thomas Chen. Thank you. Now, the first question. Now, that will be explored in details in the clause-by-clause process. Now, I think both the MIC and the MTP are included. That is under the definition for committees. Now, after a review is conducted by the medical tribunal panel, and then an amendment is made, then the date will start counting from when the amendment is made. If not, the appeal period would start counting from the day when the conviction was handed down. Now, the third question is in relation to the investigator, whether there would be an establishment and whether additional funding is required. Concerning increasing manpower, the Department of Health will indeed apply for additional funding. Concerning the exact size of the establishment, that will depend on the availability of resources. The final member in the first round, Mr. Dennis Leung. Thank you, Chair. I have 3 questions. Now, the most crucial factor determining whether complaints can be handled effectively and efficiently is about the manpower of the MTP and the MIC. Now, the housing authority would employ retired police officers to crack down on abuse of public housing resources. So will the MCHK do the same? Besides deploying their own in-house personnel, they may also engage retired police officers to act as investigators to speed up the investigative process. Now, second question. How much funding will be applied to support the enhanced mechanism? And third question, sometimes the patients will obtain medical records from the hospital authority. Now, the standard is 1 month, but sometimes the hospital authority would only furnish the reports very close to the deadline. So can the hospital authority do better? It's a very simple digitalized process. It only requires a click of a button to print out the reports. So, will the hospital authority digitalize its service and make available the medical reports to the patients in digital forms or even by use of AI? Now, I was involved in the case as well. It took me a lot of time to dig through all the paper documents, so digitalization may be the way forward. I'm also concerned about the availability of expert witnesses. Are there any incentives to encourage more local professionals to act as expert witnesses? The standard is very high because doctors would have to be in the occupation for a decade or more to become experts. Now, in the mainland, patients would get a very brief report right after the consultation. So can we ask local doctors to do the same? Can they compile a simple report after consultation to facilitate the compilation of reports by expert witnesses? Secretary. Now, concerning the right candidates for investigators, I thank Mr. Dennis Leung for your suggestion. Retired police officers may be the right candidate, but it is up to the Medical Investigation Committee to decide what kind of investigators are required. Retired police officers may be suitable for certain cases, but some other cases may require the expertise of doctors and nurses. It's up to the MCHK and the MIC, but I think your message is heard. Now, I think we should not put the blame on hospital authority. Many a times, the complaints would involve doctors in the private hospitals. Now, according to the law, the hospitals have the duty to furnish the report to the patients within a month's time. True, usually photocopies would be made to patients because some private hospitals have still yet to digitalize their medical record system. So that depends on whether the medical record itself is in paper form. So, bearing in mind the deadline, hospitals should furnish the reports to the patients and the family members in a timely manner. Concerning expert witnesses, whether we should compile a summary for each case to facilitate the writing of reports. Now, for inpatients, there would be a case summary, so that should usually suffice. However, in relation to complaints or professional misconduct or whether mistakes are made at a certain step, a summary report would not be enough. We may have to look at each order, prescription, or procedure taken. So as an expert, they would sieve out the unimportant parts. So they may stick a post-it on the important pages and read them in detail, and they would simply skim through the unimportant parts. So there are also some rare diseases with few experts in Hong Kong. For example, pediatric cardiac diseases and neural diseases. So sometimes the MCHK would rely on overseas experts. That concluded the first round. Two members have indicated wish to speak for a second round. There is still time left, so I will start a second round. Ms. Rebecca Chen, Mr. Adrian Ho, and Dr. Thomas Ho. Ms. Rebecca Chen, please. Thank you. Now, besides scrutinizing the bill clause by clause, we are talking about policy matters for this part. There are lots of related questions, including medical complaints. 4 minutes are not enough. And there are also a lot of administrative issues. Depending on the government's attitude, that may cause members to propose amendments. Now, it's only the government's stance that administrative issues need not be stipulated in the law. Now, actually, members can raise amendments to stipulate in the law that a certain standard is required for the investigators. Now, justice 15 years late is not about the administrative issues or logistics. It's about the doctor's ethics, the conduct of operation, how the incision is made. These are professional stuff. justice delayed is not just about financial matters or marketing. It's about professional investigation. Complainants are not necessarily knowledgeable about this. So that's why I quoted the example of the UK. Should there be an established team of investigators? That's something only I can discuss during the policy stage of the bill. And also, after the bill is passed, the Department of Health will have to hire many more manpower. Now, you can also consider adding the 90 Legislative Council members to the list of investigators because you are telling us that no training is required. You can list us amongst the 280 investigators. So even when you are saying that the power is delegated to the MCHK, there must still be a framework. Concerning how the investigations are conducted. Even police officers have to go through the police academy before they tackle cases. They shouldn't receive training on the spot. So we have to have a framework for the standard of investigators. The government must have a role to play. It must be clear, and whether it is a full-time or part-time work. Say an accountant can work as a part-time investigator. That doesn't make sense. The goal is to shorten the waiting time of complaints and also to the benefits of both the patient and the doctor. So without spelling all the details, can you at least give us a framework? If not, we will be the one to do it because it makes a difference. Second, about transparency. So when there are disputes, sometimes the complainant doesn't know why the wait would be so long. Why 15 years? So you have many reasons like a huge backlog and different complications. But I'm talking about how you are communicating the delay to the patients. Now, according to the bill, you will strengthen the role played by the Secretariat and enhance transparency. So my follow-up question is, in the future, will the Secretariat set up a department or case manager, just like the hospital authority? Would you ask the investigator to tell the patients about the progress of the case, or will the Secretariat designate case manager or liaison officers to tell the patient about the progress of the case? And how many more staff members will the Secretariat have to hire?
Secretary. The Health Bureau oversees the policy. That's why, in the legislative amendment, we have to put things into the law. The implementation is left to the MCHK or even to the MIC. We amend the law, we make the policy to empower the MCHK to do their job. Mr. Leung mentioned that some organizations hire retired police officers for investigation. I will not rule out that possibility. But what kinds of cases are best for retired police or nurses? We should not box in the MCHK on that point. Boxing the MCHK in will be detrimental to the work of the MIC on whether we will have full-time officers or whether we will have case managers, and that will be left to the MIC. If the cases require police officers or retired police officers, the MCHK will consider hiring people on a full-time basis from a police background. The Policy Bureau should not be restricting the MCHK's options for the work, because doing this may do nothing to help the MCHK with the work. Now, on the UK's example, their medical council is very different in terms of their composition and function. They no longer hold inquiries. They have contracted out the process. They have a very small number of doctors on the council. In the UK, 50% of the members are lay members. So that's the UK's equivalent of the medical council. So we have to be careful with what example we are citing. I am not asking for half of the MCHK being lay members. I'm simply asking about the training framework for investigators. Otherwise, even electrical members can become investigators. I am not citing the UK's complaints mechanism. I'm not asking for a 50-50 split of doctor members versus lay members. I was simply asking about the framework for investigators. Will there be guidelines? I'm not saying we should fully replicate the UK's medical council. Madam Chair, I wish to finish my sentence. It wasn't just Ms. Chen mentioning the UK. There were calls for following the UK's example in the composition of the medical council. The UK's medical council is vastly different from Hong Kong's medical council. The UK's medical council does not even hold inquiries. Citing the UK's medical council as an example would be misleading. The call for 50% of the members being lay members have been made. Citing the UK as an example is misleading. Singapore's medical council has no lay members. I'm not saying that is the right approach. I'm simply saying we should be careful about citing overseas examples when we discuss the local situation. Members of the MIC are not the same as investigators. Different organizations can nominate members of the MIC. Altogether, there are 280 organizations, each nominating 10 members. Those members are not salaried members. We invite those members on an ad hoc basis to join the MIC or the medical tribunal panel. The investigators will support the MIC during the investigation. So the investigators will be salaried positions. Those positions can be part-time or full-time. The current legal framework says that only members of the PIC and members of the Secretariat can serve as investigators. Our proposal seeks to allow the MCHK to hire outsiders to serve as investigators. If there are organizations nominating serving electoral members as MIC members, electoral members can do so. We did have electoral members serving as members of the PIC. We are grateful for that. We have professionals in electrical. We got accountants and barristers and solicitors. Each organization can nominate up to 10 members. So we welcome electrical members upon nomination serving as part of the team for investigation and inquiries at the MCHK. Mr. Adrian Ho. Now, some questions for the Secretary. The bill proposes to abolish suspended sentences. There will be a 4-tiered penalty system. We have seen minor issues or clinical errors. The medical council used to hand down suspended sentences as a way to give the doctors involved a second chance. So why are we abolishing suspended sentences? Now we will be left with extreme options, either just a fine or revocation of the practice certificate. Will our new penalty system deter doctors from trying out innovative treatments? I'm all for adding 3 laypersons from healthcare professions. Getting healthcare professionals to serve as lay members will lead to broader representation, and this can also foster interdisciplinary collaboration. That's the pro. But then there's a flip side. These healthcare professionals are also from the healthcare sector. The current reform proposal should make one thing clear to the public. We should tell people what this reform is all about. How do we explain this point clearly to the public, that as we add 3 lay persons from the healthcare sector to the MCHE, how do we explain the point clearly and allay the concern or dispel the myth that it's doctors shielding their own kind? And then now there are 800 plus cases in the backlog. What's the longest case? Do we have specific goals for clearing the backlog? Do we have a fixed deadline for clearing all the backlogged cases? Secretary. With the current penalties, there is a huge misconception. Once a doctor is suspended or disqualified, once the removal kicks in, the doctor will have to apply for the restoration. Now, of course, it's in very extreme cases that a doctor is disqualified for a day. Maybe the doctor is disqualified for a month. That application for restoration may take a long time. Now, for suspended sentences, the public sees a doctor get disqualification with a suspended sentence. So in the end, neither the doctor nor the public is happy, because when a doctor is struck off the register, the doctor has to go through a lengthy process to apply for the restoration. So when a suspended sentence is handed along, the disqualification does not take effect. Something is seriously wrong with the current system. The penalty has to be focused. With the 4-tier penalty system, things will be clearer. For a permanent removal, there will be no restoration. If there's a fixed term disqualification, say 3 months, the doctor will have to apply for restoration in the register. Suspension is a different matter. The doctor's practicing certificate is suspended for 3 months. Afterwards, it's automatic restoration. So the doctor will be barred from practicing for 3 months, but afterwards, the doctor will be able to practice again. It's like handing down a 3-month jail term. The prisoner shouldn't have to apply for release after 3 months. On suspended sentences, maybe the thinking is that the doctors should not be struck off the register immediately. There should be observation. So That's why we're introducing conditional practice. Now, for some doctors, there's nothing wrong about the professional conduct or ethics. It's simply a technical mistake. The doctor performed a procedure that fell short of the standard. The new penalty system will allow the MCHK to allow the doctor to keep practicing, but the doctor will be barred from performing certain procedures, such as endoscopy. Once the doctor meets the requirements again, they can perform the procedure again. This will lead to greater clarity and also greater fairness for the doctor. So the doctor will be barred from performing certain procedures, but not barred from practice. So this is also good for the community. What good would it do when a doctor is barred from practicing everything all of a sudden? Now, on laypersons as members, lay members lack professional expertise. These lay members need help just to make sense of the professional jargon. Now, for lay members who are not doctors but from the healthcare sector, they know more about treatment. I would not say that non-doctor healthcare professionals will always be on the doctor's side. Even doctors will not be on the side of other doctors who have committed misconduct. Maybe people from the non-medical sector will go after doctors, and they make it a point of doing so. Some people suggested doing this. There may be dispute, there's conflict of interest, etc. Lay members with the healthcare background will have the expertise, and that will help with the proceedings. On the outstanding cases, that's a legacy issue. This point was highlighted by the Ombudsman. Now, there were 18 cases taking more than 8 years. In just 6 months, the MCHK has handled 13 such cases. The remaining 5 cases are slated for inquiries within the rest of this year, and that's the solid work done. We cannot commit to a hard and fast deadline for each particular case. That's because some cases are more complicated than others. Thank you. Dr. Thomas So. Thank you. Just one question. It's about the scope of professional misconduct. We all accept this is a broad idea. So I want to ask a follow-up question. The Secretary also mentioned the screening mechanism, meaning the chairperson and the deputy chairperson of the MIC can screen out an application if the case is groundless or frivolous, or when the information is insufficient. In early 2025, there was a council question. From 2020 to 2024, there were 7,000 cases dismissed for being groundless or frivolous. That's 98%. That means the vast majority of the complaint. I understand the volume. Based on what the Secretary said, complaints of professional misconduct were dismissed for a lack of evidence. Is there a review system for dismissed complaints? Are there complaints of professional misconduct that are dismissed simply for lack of evidence? Now, if a complainant disagrees with the ruling that the complaint is groundless or frivolous, would there be a review mechanism? Before I allow the Secretary to answer the question, I will extend the meeting by 15 minutes.
At the screening stage, that is definitely necessary because we do receive a lot of complaints which are groundless or frivolous. For example, wrong name of the doctor, a typo, or a complaint which has nothing to do with professional misconduct, for example, a noise complaint at the residence of the doctor. Now, we have analyzed the cases from the past 2 years. There were more than 1,100 cases. More than 41% of the cases were dismissed during the screening stage. So that's by way of the figure. 52% of the complaints lack sufficient evidence to prove that there is potential professional misconduct or problematic ethics. 7% of the cases were referred to the inquiry panel or the future MPP. If evidence was lacking, or if the wrong kind of evidence has been submitted by the complainant, when additional evidence surfaces, the complainant can submit the evidence in supplement. So that's why there are delays sometimes. Sometimes the inquiry panels have no way to follow up on the cases because the information were not substantiated. So that was our experience. Any follow-up question? In addition to the reply concerning the dismiss, is there a reprieve concerning the dismissal of complaints? Is there an appeal mechanism or review mechanism for the dismissal? In the lack of new evidence, there is no ground to apply for an appeal. Now, the PIC is simply looking at the evidence available to see whether a case can proceed. In the lack of the most basic information, it is impossible for the inquiry to continue. Now, if the name of the doctor provided was wrong, when the correct name is provided, then the inquiry panel can proceed. But that depends on whether there are new evidence provided by the complainant. Next, Ms. Christine Fong. Thank you, Chair. I have some follow-up questions in relation to the policy. Now, the bill mentioned the regulatory framework. There will be an internal medicine, surgical, as well as a midwifery framework. Now, midwifery involves both midwives, nurses, and doctors. So in that case, will there additional regulations? Will there be additional regulations on the profession? Now, this is a very comprehensive and far-reaching reform. That's great. But it gives rise to the question whether Chinese medicine practitioner would be included, and also allied health professions like physiotherapy, optometrists, radiographers, and also medical equipment operators, will they also be submitted to the regulation by the MCHK? So how far will the scope be? Secretary, now internal medicine, surgery, as well as midwifery, these are just the disciplines of the doctors. Now, in regulating different medical professions, there are different ordinances. For medicines and medical equipment, they are subject to regulation under other ordinances. The medical registration ordinance only concerns doctors or Western medicine practitioners. The Chinese medicine profession is subject to another ordinance. Nurses have their own ordinance, and the same for dentists. Now, the nurse registration ordinance and dentist registration ordinance 2 years ago, amendments were moved to amend them. For allied health professions, including physiotherapists, optometrists, and so on, they are subject to the allied health professionals ordinance. So over the past few years, we have conducted a revamp to the regulatory framework of the medical profession as a whole. So we thank the Legislative Council for your support as well. So this time we are reforming the regulatory framework for doctors. It has nothing to do with Chinese medicine doctors and nurses. Now, in follow-up, does the Secretary have a timetable for initiating reforms on other medical professions? It has been done last year. We have already updated the Allied Health Professions Ordinance. If there are no follow-up questions, it's about time we conclude this meeting. We have spent 2 hours and 10 minutes on discussion of policy matters. The Secretary has responded to 16 questions. Now it is now the AOB stage. On the 17th of September, a Thursday, as well as 25th of September, Friday, between 9 and 11 a.m., we will proceed with the remaining procedures. So the Secretariat will send out notices to members. If there are no AOB, the meeting is adjourned. Thank you.